Hello, everyone. Good afternoon from Florida. It's 1:30 p.m. Eastern Time here in Florida. And good morning to those of you out on the West Coast. Thank you for joining our webinar today. We're so delighted that you've joined us to talk about why diligent Medicare compliance in 2025 is critical and why your organization should partner with a specialized MSP provider. A unique topic here today that we've never quite tackled or presented in a webinar, but with so many Medicare secondary payer initiatives coming out over the last few years, and Sanderson Firm has been asked a lot of questions about potential liabilities and consequences of utilizing perhaps a third-party administrator for your Medicare compliance services, how that might impact your claims organization, and what really it means in today's environment to utilize perhaps a TPA or an inexperienced Medicare vendor that might not be meeting your needs. Okay, just a moment to tell you about Sanderson Firm if you're not familiar with us. We only do Medicare Secondary Payer. We specialize in it. We believe we are the best at it, and that is what we do. We are a fully woman-owned business, certified WBE. We have a national footprint, and we service clients across the country, including self-insured companies, TPAs, and governmental entities. Our staff, while we are a law firm, and as you can see, we have several attorneys on staff, our staff are comprised of legal, clinical, and claims professionals. We just recalculated our years of experience here at Sanderson Firm. I just got the final number today because we've been doing a lot of hiring here at Sanderson Firm as we grow a lot. And collectively, across our employees, we have 500 years of experience in Medicare secondary payer. So again, really proud of the team that we have here. And I think that, with the combined clinical and legal expertise, we're producing optimal outcomes with Medicare secondary payer. Our team of employees, I think we're actually almost at 50. I'm having a double check on the count because, like I said, we've been hiring a lot of people recently. We have tons of experience, and so we're happy to be leveraging that expertise. First of all, before we get into today's topic, I want to talk a little bit about the DOGE agency, the new government efficiency, essentially agency that's been created by the new administration. We've had a lot of clients ask us here at Sanderson Firm, what impact are the recent federal changes having upon Medicare secondary payer and the Centers for Medicare and Medicaid Services? So we're going to talk a little bit about that. And then we're going to level set about Medicare secondary payer, their interaction with third-party administrators, and generally what third-party administrators do and what they're good at, and some things that you might want to be sure that they're handling properly for you if you utilize a TPA for any of your MSP responsibilities. We're actually going to spotlight specific examples that we've come across here at Sanderson Firm, anonymously, of course, conditional payments, Section 111 reporting, and Medicare set-aside. So we're going to go through that, and so you can kind of see and get some insight into some of that. Okay, so recent impacts. So as far as the DOGE's impact on the health and human services, right? So on March 27th, 2025, HHS announced a major restructuring via an executive order entitled Implementing the President's Department of Government Efficiency Workforce Optimization Initiative. So on the flip side, from the Biden administration, which increased the HHS budget by 38% and its staffing by 17%, we have obviously the complete opposite happening here with the Trump administration. They're reducing the workforce by 10,000 full-time employees. And overall, the workforce size went from 82,000 to 62,000 full-time employees after this DOGE cut, right? So a lot of changes, a lot of personnel cuts. And ultimately, the administration reports are claiming that the reduction will save taxpayers $1.8 billion per year. The HHS has 28 divisions, but as of the March 27, 2025 job cuts, the restructuring consolidates these down to 15 divisions. And overall, the regional offices across HHS will be reduced from 10 to 5. So what HHS has said about this is that it will improve Americans' experience with the Health and Human Services Agency, making it more responsive and efficient, and while maintaining that Medicare and Medicaid and other essential health services remain intact, right? So the new HHS Secretary Robert F. Kennedy said, We're not just reducing bureaucratic sprawl, we are realigning the organization with its core mission and our new priorities and reversing the chronic epidemic with diseases, right? So essentially, this is going to do a lot more at a lower cost to taxpayer. And that's what's alleged. Of course, we're not saying that anything that the current administration is doing is right or wrong. We're just sharing what they've said about what they're doing with the agency. So very interesting, right? We'll all see if that's true. As far as we know, there's been no changes to the actual Medicare and Medicaid programs and benefits and eligibility so far. So that, I think is important as far as Medicare spending, Medicare secondary payer. Ultimately, I do think that the administration knows that the general public finds great importance in these programs, and there's a lot of people that rely upon Medicare and Medicaid, but can they maintain Medicare and Medicaid with less staff? And that's what's to be seen. And that's what's to be seen, with Medicare secondary payer, right? So, we know that the restructuring of CMS specifically, which falls within HHS, they're going to reduce it by 300 full-time employees. And other HHS agencies that also fall under the HHS umbrella are receiving workforce reductions. For example, the FDA, 3,500 employees reduced, CDC, 2,400 employees reduced, and the NIH, 1,200 employee reduction. So significant, right? So Brendon and Andy and I were talking about this earlier, and we were saying we don't know, right? Candidly, I believe that you were going to ask someone at CMS, Andy. I believe we're not 100% sure how many folks are actually dedicated to MSP over at CMS, right? I mean, there's certainly people that work at the two recovery contractors of CMS, the BCRC and the CRC. Then you have the WCRC, right, that reviews MSA proposals. We have regional offices that have a hand in Medicare secondary payer. We have the policy folks over at CMS, over MSP. And we're only aware, I believe, of one person actually laid off within the MSP division. Do you want to comment on that, Annie?
Yeah, I don't yet have an update on exactly how many are in the MS division, but the division itself is pretty small, and I think they work really hard at hiring really experienced folks. So I do think that was a hit to that MSP division, but I'm not aware of any other, planned layoffs that will impact the division at this time. But I am looking into it. As most of you know, I'm serving as the president of the National MSP Network this year. So I'm looking into it with that role as well. And we'll be definitely happy to share that in upcoming webinars, any updates we have in that realm.
Great, thank you. So, I mean, I think long story short on DOGE and MSP, right? So we've told you all about all the reductions going on within the federal government, but we're only aware of one person in the MSP division laid off. So I think MSP is fully staffed. I mean, of course, that's subject to change, right? We're only, 4 months into the new administration, so things could change. But as it stands right now, we've only lost one person in the MSP division, and Medicare continues to work on initiatives around MSP. And arguably, they've been more active than ever, especially with MSA reporting starting just earlier this month. So, I think I wouldn't take any solace in the DOGE causing less MSP initiatives. I think it's status quo, and we keep moving forward. Brendon, why don't you tell us a little bit about the end of the Richardson waiver?
Yeah, sure. So this is a bit of a just rounding off the updates here. This is more of a sleeper. I haven't seen too much talk about this in the industry, but it's certainly significant. So just as in terms of a background and like level set of what the potential issue here is, generally speaking, when federal administrative agencies propose rules, they've been granted authority by our Congress to do that. When these agencies propose rules, these proposed rules can turn into laws. Right? Like we've seen that most recently when CMS issued its final rule on civil money penalties, and we see now that is effectively the law. Generally speaking, though, when these agencies propose rules, these rules are subject to what's informally known as a notice and comment procedure. So when the rule is proposed by the agency, such as a CMS, that rule is published or a notice is made online on the Federal Register, and it allows interested parties from the public to comment on the rule. So, John Doe may say, hey, CMS, like I was looking through your rule and I've identified a gap here. Can you make sure that the final rule addresses this? Or, hey, CMS, I see that this is worded this way potentially in the final rule. I think it can be improved this way, right? So that's the whole notice and comment procedure. The thing is, though, in the original text of the Administrative Procedures Act, there's a line that says that matters relating to, quote, public benefits, which has been interpreted to extend to Medicare benefits and CMS, these matters are not subject to the Administrative Procedures Act notice and comment procedures. What's interesting, though, is several decades after that, in 1971, the then Secretary of the Department of Health and Human Services at the time, a man named Elliot Richardson, wrote something which is now known as the Richardson waiver or the Richardson memo, where Elliot Richardson essentially said, hey, look, we know that HHS and all of our sub-agencies, so CMS, NIH, CDC, all these agencies don't have to subject themselves to the APA's notice and comment procedures. However, as a matter of policy, we at HHS and all of these sub-agencies are going to abide by this notice and comment procedure. And of course, right, like that's been the policy in place for decades. And we saw that most recently play out with CMS's final rule. So maybe some of you who are super tied in may remember the original proposed rule itself. And in the proposed rule, there was talk about, if a responsible reporting entity had quote unquote contradictory data, that would subject them to civil money penalties. Or if an RRE, that same entity exceeded a certain threshold error tolerance threshold in any given amount of quarters, then again, too, that entity would be subject to civil money penalties. We saw through the actual notice and comment procedure when CMS posted that proposed rule to the Federal Register itself, some of the comments were like, hey, CMS, this is kind of confusing. Like, can you explain this threshold to me? Or what do you mean by contradictory reporting? Can you give examples of that? Right. So it's really unclear. And I believe, at least I believe, through the process of this procedure, CMS crafted a rule that just simply made more sense. So CMS went away from the actual technical side of whether the data was correct or not. And now the final rule today is all about timeliness of reporting. So it's interesting now that CMS just last month, the now Secretary of Department of Health and Human Services, RFK Jr., wrote a memo rescinding this Richardson waiver policy entirely. And obviously, we're in the sort of the flavor of the month now is government efficiency and fraud, waste, and abuse. And in his policy memo, RFK said, hey, this process of CMS, for example, drafting a rule and having that go through the 60, 90, 120-day notice and comment period, that's inefficient. We want agencies like CMS and agencies within HSS to be able to get these proposed rules out quicker. So that's obviously a major topic as far as what does the elimination of this Richardson waiver policy mean for CMS stakeholders? Short answer is that we'll have to wait and see. I do think it's a good thing, of course, that thankfully this happened recently and didn't happen back before when CMS had its proposed rule on the civil money penalties, because or else, who knows, CMS could have came out with its old proposed rules and it would have been total chaos on the reporting end. But I do anticipate potentially some legal challenges to this in the future. But with that, I will turn it over to Annie.
Thanks, Brendon. I think another interesting piece about that too is, right, this is round 2 of Trump, and we all went through round 1 in this MSP stakeholder industry. And not a whole lot changed in MSP during that first administration. I don't anticipate a whole lot more to change this time because, right, we tend to save money in this area. And I think also, right, you have that Richardson waiver, like, okay, we're not going to abide by this, but then you also, Trump's whole game in his first term and this term is always to kind of deregulate. He doesn't like making new regulations. So it's such an interesting juxtaposition. So I appreciate you talking about it, but like, stay tuned, everybody, right? We're all staying tuned. because I don't anticipate it, but you're right. I think there would be some legal challenges for sure, Brendon. So thanks for covering that. So what we wanted to do quick as we move into our topic today, we wanted to do a quick level set, right? We recognize that not everybody has been on our webinar and not everybody has been maybe living the MSP compliance dream like the three of us have for most of our careers. So quick level set. We will be talking about the 3 areas of recovery, and we have case studies in each area. So we'll be talking, I think, first about conditional payment recovery and some of the issues that we see there. We'll be talking about Section 111 mandatory insurer reporting and Medicare set-asides. What does that mean? Well, 42 USC 1395 YB is where we all hang out. And when you look at what that law says, it says you have to reasonably consider Medicare's interest when settling out a case. And there are 3 different areas that you have to do that in. The first one is that Section 111, mandatory insurer reporting. There's statutes, there's regulations, there's sub-regulatory guidance that says what we need to do for responsible reporting entities, which are, work comp carriers, self-insured, all of that, any non-group health plan liability carriers, no-fault carriers, right? The goal with doing the Section 111 reporting is taking care of, on a quarterly basis, getting information over to Medicare about the claim involving a beneficiary, a Medicare beneficiary. That's to coordinate benefits with Medicare. And if you don't do it, you're at risk of those civil money penalties, which Brendon was talking about, which is up to $1,000 per day per claim annually adjusted. If you don't take care of what you're supposed to be taking care of in the conditional payment realm, this includes Medicare Advantage plans, Part D, prescription drug plans. You've got some statutes, regulations, and sub-regulatory guidance to wade through. And so it's pretty clear that the parties need to make sure that you're resolving Medicare's conditional payments, regardless of if they're with traditional Medicare or those Advantage plans or Part D plans. The goal there is recovery. It's not coordination of benefits at that point in time. Medicare wants dollar for dollar to get their money back. And if the parties don't repay Medicare, then you're as a carrier or self-insured, you're at risk of double damages. You're at risk of Treasury offsets by the U.S. Department of Treasury. And then Medicare Advantage plans and Part D plans, they don't have access to the Department of Treasury. So they sue for double damages. So that's really the risk there. And these are the things that you want to be making sure of, right? If you're using a third-party administrator to do your Section 111 reporting, you want to know where you should be kicking the tires and what you should be watching out for. Same with conditional payment resolution. And then finally, Medicare set-asides, which is kind of the bread and butter of the industry. But what's interesting here is there's nothing in the statute. There's really, I have regulations and a question mark in there. If you look at the CFR, there is a division in there, 42 CFR 41146. And then we have sub-regulatory guidance from Medicare on what to do with Medicare set-asides. The end goal here is coordination of benefits. And the risk to the carrier or self-insured, if you don't do this right, is that Medicare could choose not to recognize the underlying work comp settlement. So that's our very quick level set. These are the areas that if you're farming this out to anyone, we ask that you have a really good partner in hand to help you avoid these risks that we just covered. With that, I'll turn it back over to Heather.
So let's just talk about third-party administrators generally, right? So very common for insurance carriers and self-insured entities to outsource their claims processing to TPAs. They may issue payments to medical providers, make settlement payouts to Medicare beneficiaries, and of course, provide any other general claims processing for the insurer or self-insured entities. Of course, the TPAs may promise cost savings and cost containment, and very well, they might be doing that. But generally, when it comes to Medicare secondary payer compliance, TPAs are generally not experts in this specialized area from what we've seen. They're generalists, right? They're not equipped to aggressively cut costs for you on your Medicare beneficiary claims. So generally, bundling your MSP is not going to save you money. And again, we're going to go through some specific examples where not only was the TPA not providing opportunities for cost containment, but also not identifying areas of non-compliance and just generally, handling it data in, data out, and not providing that expertise and the compliance protection, right? And a lot of TPAs, they don't have attorneys in-house. They can't provide legal advice. They can't necessarily really give you direct guidance on how to properly handle your Medicare secondary payer initiatives. Also, because their general expertise and what they do is claims handling, they're not as dialed in to the CMS updates and MSP changes as your MSP compliance provider might be, right? And additionally, TPAs may expose primary payers, insurance payers, to double damages and penalties if conditional payments and reporting are not handled properly. Some examples, right? Generally, the way TPAs are incentivized, and of course, there could be a different model across TPAs, but generally, a TPA may get paid per active number of files, right? So, what is their incentive to try and close out this case if it's going to impact their actual income? TPA adjusters often have too many files, to closely manage them. So, we hear all the time, a lot of times, depending on the TPA, an adjuster could have well over 100 files. Is the adjuster able to closely monitor for MSP issues? So, big question mark there. Let's explore. Let's talk about it.
Yeah, so we're going to dive into some examples here, but let's level set. What is a conditional payment? A conditional payment is an expense for Medicare covered items and services for which another entity is the responsible primary payer. That's how Medicare likes to define it, right? So you have an admitted work comp claim, you've done the reporting to Medicare, but for whatever reason, the provider sent a few of the bills over to Medicare instead of to you if you're handling the workers' compensation claim as an adjuster. In those instances, Medicare will show up down the line, particularly traditional Medicare, and want to get that money back. So conditional payments are made under that condition that, hey, Medicare or a Medicare Advantage plan, we're making this payment, but if we find that work comp should have been on the hook or liability or no fault, we're going to go and we're going to ask for that conditional payment to be reimbursed. So again, they don't just apply in traditional Medicare. You do see this with Advantage plans, which is Part C, and those prescription drug plans, which is Part D. So that's our level set. We can move on to the risk here. So we have the citations in here, right? Being lawyers at a law firm, we're giving that to you. What is the risk if Medicare conditional payment liens are not timely reimbursed? Well, interest of more than 10% per annum. So when you get a demand from Medicare or from one of these Advantage plans, if you don't pay that balance within 60 days, interest starts to accrue. Actually, the Advantage plans can get even more aggressive than that. And there's case law out there, like the Western Heritage case. There's some cases out there that say if you don't pay within 60 days, it's an automatic shall pay double damages. So if we're talking about just traditional Medicare, you're looking at interest that starts accruing at over 10%. And then if it goes beyond 190 to 120 days, Medicare starts looking at sending that over to the Department of Treasury. So then you start looking at Treasury offsets against corporate tax refunds. I've seen companies end up with their ability to contract with the federal government frozen because a conditional payment balance went to Treasury. So the federal government has some pretty big sticks to hit you with if you end up with a case headed to Treasury. And then, like I said, with double damages, that's really the only tool that Medicare Advantage plans have in their toolkit in order to get repaid. And they have litigated everywhere they've litigated. They've had success in getting the double damages provision to really apply in their cases. So the citations we have here is the federal government can pursue that action for double damages, but also there's a private cause of action. So we have that citation here as well, which says a private individual or organization can step into the shoes of the federal government and sue for double damages if they're aware that Medicare paid items and services that really work comp, liability, or no fault should have paid for. So that's the kind of really scary part of this. These are the risks that you're facing if these aren't being handled well by, let's say a TPA that you're working with or some other vendor. So with that, we'll move into some of the specific cases. This is our first case example. This is a case that was handled here at the firm. Medicare beneficiary got a letter from Medicare post-settlement asking for $164,000. Prior to the settlement, the third-party administrator unfortunately did not run a conditional payment lien search. The settlement agreement terms themselves were silent with respect to how the Medicare conditional payments would be handled. So not only do you kind of have a TPA issue here, you probably have an issue with maybe the attorney who handled this, because anytime you're settling a case with somebody who's on Medicare, you got to really make sure that you're covering all the bases. So there should have been a provision in the settlement documents that talked about this, but it wasn't there. So the claimant gets this post-settlement, right? The Section 111 reporting went through. It told Medicare the case existed. Medicare found a lien. They tendered it to the claimant and said, look, you got a payment. You got the settlement payment. Please refund us $164,000. The TPA filed a lien dispute with Medicare, but that dispute failed because the TPA filed the dispute without prior authorization or proper authorization. This is a mistake that would not be made by an expert MSP provider. I really cut my teeth on conditional payments when I came into the work comp industry, and having the right letter of authority on file so that you can talk to Medicare is a big deal. Medicare will not talk to you if you don't have that on file. And a TPA, unless you're an in-house adjuster for the carrier, the TPA, Medicare is not going to talk to you without that authorization. So because of that mistake, the TPA then instructed their client to simply pay the lien amount. Like, whoops, we made a mistake. We couldn't get, a lot of times folks don't read what Medicare has written when they reject these disputes or appeals. They'll tell you why. And what's going to happen with that is it's going to be dismissed. They'll just dismiss it out of hand because they don't have the right authorization. It's essentially the idea of like, is your appeal being heard on the merits, or are you getting kicked out on a technicality? And in this case, they got kicked out on a technicality. Like, you filed wrong. But the answer to it is not to make the carrier pay $164,000. The answer is get this over to somebody who knows what they're doing so that they can help fix it. And so in this case, the TPA's client, the carrier, has a relationship with us, approached us and said, hey, can you help us here? Like, we don't think this should be happening. Our team, right, we've got a team of experts that work on this day in, day out. We successfully went ahead and filed the appeal and reduced that lien down to $0.00. That's the other thing to keep in mind here. Better than 90% of what traditional Medicare puts into these demands or their notices, it's not even related to the claim. So you never want to pay that $164,000 without examining it very closely. So due to the expertise over here, we also used hardship waiver on this one. So if the balance really is going against a beneficiary, like post-settlement, we have the ability to look into hardship waivers for that individual based on what's going on in their case. So we use that as well. This was a different appeal mechanism that we deployed than the TPA too. So there are other things that if you're looking at a firm that specializes in this, these are all of the things we think about. We're not just thinking about, related or not. We're going to try to stick the landing on the procedural piece so that you're not getting kicked out on the technicality. And then you're going to stick the landing, as many as you need to, on the basis for your appeal or your dispute. So the claimant's attorney did inform our office that the success prevented that carrier from being sued by the beneficiary for mishandling the file, right? So there could have been a bad faith or unfair claims practices suit brought by the claimant and the claimant's attorney in this case. So we also protected them from that. So, not all TPAs behave this way. That's not, as Heather mentioned from the beginning, we've anonymized this. We know that there are some good folks out there, but again, they're generalists. This is not where they live day in, day out. This is not how they cut their teeth. This is exactly what we look for here with our eagle-eyed attorneys and our support staff. So that's our first case example. We've got another one. So this one is a case where the TPA gets a demand from Medicare with the high claim caseload, right? TPA doesn't pay the balance within 60 days. So you just heard me talking about that. 60 days, interest is going to start to accrue at 10% or greater. This actually keeps trucking along. And around the 90-day period post-demand, a notice of intent to refer gets sent. This is I call it a screamy letter from Medicare. It's hard to miss. It's in all bold caps. And it's telling you, if you don't do anything, this is going to the Department of Treasury. So it usually gets people's attention. The TPA adjuster had such a high claim caseload, and for whatever reason, they don't get to filing the appeal within 120 days. So let's back that up, right? You've got 60 days to make payment, but you've got up to 120 days to file your formal appeal. If you don't do that, you're going to get thrown out of the administrative process. And it will take some higher level work to kind of get that reinstated. So, but around the 90-day mark, you're going to get that screamy letter from Medicare that tells you, hey, look, you've got about 30 more days to file your appeal. And that didn't happen. They missed it. So because of the TPA's mistake there, the full balance ended up transferred over to the Department of Treasury, where the carrier or self-insured was beginning to receive collection calls. So the U.S. Department of Treasury does hire private collection agencies to make calls on their behalf. So you can start getting harassed if you're a carrier or self-insured if they opt to send it to the collections. Alternatively, they can just perform an offset. If your company is due federal dollars for whatever reason, the Department of Treasury can intercept those funds. I've seen this happen in municipalities in particular, where everybody shares the same tax identification number. So you have, let's say it's September, you've got the local school district, they've got federal dollars trickling in to pay for schooling, and the police department has an unpaid conditional payment matter for a work comp claim with one of the police officers. I've seen Medicare take that money from the federal dollars for the school district to repay the police department conditional payment lien. That's what's at risk here. And in this case, Sanderson Firm was able to help the client leverage their open debt report. We were able to get this case pulled back from Treasury, but it takes a while to do. We have to get it back from Treasury, situated back in front of the right contractor, and then we use whatever tools we have to have them really take a look at it on the merits, not because it was technically deficient and missing the deadline. So we have a lot of tools at our disposal. Open debt reports, like I just mentioned, will help you with that. That's available to carriers and self-insureds. It gives you an idea of any cases that could be heading towards Treasury, what the debt looks like. The G2G program, originally called government to government, it's expanded and private entities are allowed to use it. So we will also keep an eye on that with you and team with you if you work with us to make sure that your tax refunds don't get interrupted or your ability to contract with the federal government, et cetera, isn't impacted. So that's another case example. And then we have one last one that I'll go over. So this is one that we're working on right now. A self-insured employer reached out to me. They have a demand from CMS on a no-fault claim. This claim occurred many years ago and resolved many years ago. What's interesting is the internal adjuster at the self-insured, who's really savvy at handling these cases, looked into it, and the claim number that's associated with Medicare's case is someone with a similar name, but it's not the same name. It's not the claimant that's involved in the no-fault case. Medicare's case involves somebody who is deceased. The self-insured claimant is actually still alive. Further investigation reveals that the TPA that was previously used, and this is a long time ago, they have not used this TPA in a long time, had used, they'd basically taken the name and information for a different claim, probably with one of their other clients, and reported that to Medicare via Section 111 reporting, this is going to be a good segue because we're going to talk about Section 111 next. So basically you have an issue originating with the Section 111 reporting, an error that the TPA made, now showing up, rearing its head in the conditional payments realm, where Medicare's trying to get money back on a claim that's not even associated with the self-insured. So the appeal attempts by the self-insured, they called in, they got really good advice, but every time they filed everything in a relatively easy to understand way, they ran into like a dead end with the recovery contractor because it gets really bureaucratic. So at this point, they've turned it over to us at Sanderson Firm, and we're working through the issue with the reporting to then get this case completely terminated because it's not even the right person. But you're also talking about, look at the time they're spending now, years later. Statute of limitations is run, the 1-year time, all of that stuff is run, and they're still having to defend themselves against this. So please be very careful, making sure that if you're using a third-party administrator to do your Section 111 reporting or to handle your conditional payments, that they're doing it right. And if they're not, or you're concerned about this and want to partner, chat with us. That's why we're here. All right, let's go into Section 111.
Before we hop into any Section 111 examples, let's just level set, talk about what Section 111 reporting is. So Section 111 refers to Section 111 of the Medicare and Medicaid S-CHIP Extension Act of 2007. It's essentially a piece of legislation that requires entities such as no-fault insurance carriers, workers' compensation insurance carriers, liability insurance carriers, and self-insured entities to report certain claims information to CMS that involves Medicare beneficiaries. So obviously this piece of legislation has been on the books for decades, but for the longest time, there was no teeth in the actual reporting rules. And I was aware of certain entities who actually had claims. They were technically responsible reporting entities, but they just simply never reported claims at all. But of course, all of a sudden, things get serious, and that changes in October 11th of last year. So October 11th of 2024, that's when CMS's final rule on civil money penalties went live. And so now, if an entity is an RRE, and they fail to report either a settlement or their acceptance of ORM, essentially their acceptance of the claim to the federal government, they will be subject to civil money penalties of up to $1,000 per Medicare beneficiary record that's reported. So that the exposure on just one Medicare beneficiary record, when you account for inflation, is something like $520,000, over $500,000, just for not reporting one Medicare beneficiary record to the government timely. And obviously, the government is clamping down on this is because the government wants more information. They want to be able to coordinate benefits better for their Medicare beneficiaries. So the last thing Medicare wants is to have a beneficiary and have the government pay for that person's treatment and not be reimbursed when some other entity out there, right, the insurance carrier who accepted this compensable claim, gets a windfall and doesn't pay for any of this person's medical care just because that individual happens to be a Medicare beneficiary. So Section 111 reporting just facilitates CMS's recovery of conditional payment and allows CMS to sort of like know what's going on. Is there a carrier involved? Was the claim accepted? Was it denied, etc. So with that, we can hop into some examples here. So the reality of using TPAs for your Section 111 reporting. So point number one, right? Most primary payers don't realize that to the extent that they utilize a TPA for Section 111 reporting, if there is an error and the civil money penalty is imposed, that civil money penalty is not being levied against the TPA or whatever third party you use for your reporting. That's levied directly against the actual responsible reporting entity themselves. I think a lot of folks might get confused by the terminology of it all, right? Because you have your Section 111 recovery agent, and your agent is handling conditional payments, and so you think everything's operating smoothly on that end. So you close your eyes, cover your ears, you think everything's okay. And similarly, there's a Section 111 reporting agent, right? The reality is, if your agent messes up, that civil money penalty is coming against you, the RRE directly. Now, you may have some sort of a separate claim, right, like an errors and omissions professional liability claim against the entity who messed up the reporting. But again, like when that CMP comes in, federal government's not looking at anyone else. Federal government says, okay, cool, they're your reporting agent. We don't care. Strict liability for you. You're responsible. You're the RE on record. You've got to pay this fine, right? So not a lot of people know about that. So just remember, you can't duck behind your reporting agent. Make sure when you're selecting your reporting agent that it's an entity who is an expert on these MSP matters. And again, just generally, this has been highlighted before as well too. So TPAs generally are not specialized in the Section 111 reporting / data oversight field. Thus, it is highly likely that the TPA will not notice untimely reporting. And so getting into one real life case example here, you can really see the seriousness of getting the reporting piece wrong. So we had a file that came in, a TPA approached us. This TPA let us know that they were the Section 111 reporting agent for a large, maybe medium-sized insurance carrier. And so this TPA, this was back at the time when CMS's final rule on civil money penalties had been passed. This TPA approached us and said, hey, we just want to make sure that we're doing right by our client, the insurance carrier. Can you just like double check our reporting data and make sure that we're reporting this correctly for our client, the insurance carrier? So we said, sure, no problem, right? We do these audits all the time. Our audit of this TPA's handling of this insurance carrier's Section 111 data uncovered two major anomalies. Anomaly number one, this TPA was reporting indemnity-only settlements to CMS. So this by itself is not an issue that would cause a civil money penalty, This is actually an example of over-reporting to the federal government unnecessarily. For the better part of, I think, 5, 10 years, CMS has been very clear that if you have an indemnity-only settlement, the settlement that's not closing medicals, that's a settlement or a TPOC that doesn't need to be reported to CMS because CMS doesn't have a recovery interest in that settlement. And so what's happening effectively by this TPA reporting this insurance carrier's indemnity-only settlements as TPOCs is the federal government was processing and generating conditional payment liens for which this insurance carrier was not responsible for at all, right? So that's a huge administrative burden on the government, but obviously a conditional administrative burden on the RRE to pay the cost associated with disputing the lien amounts and having that lien file actually closed down, right? So that was issue number one. But by far and away, issue number two was even more insane. So this TPA was only reporting TPOCs on the liability claims. So this was an insurance carrier who they had a general liability line of business, but they also had a workers' compensation line of business. So anytime this RRE settled a workers' compensation claim, that TPOC or that settlement was never being reported to the government at all. And this RRE had no idea. So running through their claim count and sort of timing, we sort of uncovered that if our audit had not been performed, the insurance carrier had no idea. They were looking at a bare minimum, actually, of $10 million in civil money penalty exposure from their TPA from not having reported their workers' compensation claims. And $10 million is on the lower end, could have been far greater if those claims weren't reported for more than 3 years. So interesting that this happened. Something like this kind of happens when you partner with a TPA who isn't really consultative and doesn't really show you, hey, like this is what's going on with your data. This is what was and was not reported, right? Like you're not getting monthly, quarterly reports, right? Because this RE, like I said, had no idea this was happening. And so, 3 years from now, this insurance carrier could have woken up with a $50+ million bill for services just because they selected their TPA incorrectly and their TPA sort of wasn't aware of these things. So, okay, so now we can move on to an example of the PAID Act. So just really quickly, for those who aren't aware, the PAID Act was a piece of legislation that was passed somewhat recently in 2020. And this legislation requires the federal government to provide responsible reporting entities with private Medicare beneficiary information. So before the PAID Act, if you had a claim and you ran a query in Section 111, you would know that that person is a Medicare beneficiary, right? Like a traditional Medicare beneficiary enrolled on Medicare Part A and Part B. But prior to this, you had no idea if the individual was also enrolled in a private Medicare plan, right? And that's important because private Medicare plans, just like traditional Medicare, if there is a private Medicare lien, those lien amounts need to be reimbursed, or else that private Medicare plan could have a cause of action for double damages. Example of how this sort of worked was, so we had a TPA. A TPA was the Section 111 reporting agent for a large carrier. The TPA was not notifying the insurance carrier of the PAID Act data, thus ignoring all potential private Medicare liens. There was a claim that settled involving a Medicare beneficiary, and surprise, surprise, this person was not only enrolled in traditional Medicare, but they were also enrolled in a private Medicare plan as well. So none of the parties were aware of this. So this claim ended up settling for $80,000. The attorneys, the beneficiary, the carrier, they walk away, settled and done, full and final $80K. Let's go straight to the next claim. And they wake up several months later, and there is a $44,000 Medicare private lien that's being asserted against the insurance carrier. And unfortunately, the settlement documents themselves did not address what would happen, who would be responsible for reimbursing these private Medicare liens, because all parties were under the impression that this person wasn't a private Medicare beneficiary at all. So Sanderson Firm got involved, and we were actually able to negotiate down this private Medicare plan lien. The thing was, though, this lien was completely legitimate, right? So some amount ended up being owed. So rather than the insurance carrier walking away, thinking that they closed the claim for $80,000, they paid several $1,000s to resolve this conditional payment lien. And they had to do that because if they would have ignored the lien, this private Medicare plan most likely would have hauled them off into federal court and pursued an action for double damages for failing to reimburse this private Medicare plan. It actually turns out, and we learned later, that this TPA, their software system wasn't set up to collect this paid act data. So the TPA was just completely blind. And it's particularly scary for the insurance carrier in this information, right? Because we know that private Medicare plans, similar to Medicare, have a 3-year statute of limitations to recover. So for any settlements dated from when the issue was resolved on the TPA's end to collect the paid act data 3 years back from that date, the insurance carrier has to go back and say, hey, I settled these 300 claims. Like, do any of these claims have was a private Medicare plan involved? So that's obviously a hassle for the insurance carrier.
We are hearing that quite often, unfortunately. It's not just TPAs, but a lot of claim software, unfortunately and surprisingly, have not been updated since the PAID Act to provide those private plan information. And to that case example's point, I mean, the exposure, and as Annie talked about earlier, there's ironclad case law that demonstrates that the Medicare Advantage plans can sue for double damages if not reimbursed. So if you're not getting this PAID Act data from your TPA or your reporting agent, make sure that you inquire as to why and make sure you're getting that information. It's very important. Okay, we're going to flip on over to Medicare set-asides and just a brief level set. Just as a reminder, we all know MSAs allocate a portion of typically a workers' compensation settlement, allocates for future care so that Medicare does not pay for that treatment in the future, right? MSAs are designed to not only provide for injury-related care in the future, but they should be reasonably allocated, right? So let's talk through a few examples in which we are aware of TPAs preparing MSAs. So in this instance, an insurance carrier was almost completely removed from the MSA process. We spoke with this client. They never received any kind of report from their TPA about the number of MSAs being performed for them per month or for a year. They just heard nothing, right? They were just being done and being billed to the file. The TPA was only reporting TPOCs on liability claims, might be the same TPA as Brendon was mentioning before. They weren't reporting settlements on work comp claims. They didn't provide any information to the carrier on how to mitigate the cost of that MSA. And they never prepared an MSA on claims involving Medicare beneficiaries where the settlement was less than $25,000. That $25,000 review threshold from Medicare is an arbitrary workload review threshold at CMS because they cannot review every MSA, and that is not certainly an indicator as to whether you need an MSA or not. I talked about this earlier briefly, and it's not the topic of today's discussion, but we all know that MSA reporting started April 4th, earlier this month, right? On all of your settlements with Medicare beneficiaries and work comp that are over $750, you now need to report MSA information on that. So this practice by this TPA is obviously going to get this insurance carrier into trouble, and perhaps it might cause interruption to the Medicare beneficiaries' benefits. Another example, a TPA submitted an MSA on a claim with a court order signed by a judge confirming application of state law, which should have resulted in a low dollar CMS approval amount. So essentially, the court order that the client obtained was ignored by CMS, right? And this happens sometimes. CMS says in their WCMSA reference guide that they will abide by state court orders, but their actual practice of what they do and what they say in their guidance could obviously contradict each other. I'm proud to have been personally involved with this case, actually, because the TPA in this instance just told the carrier, hey, there's nothing we can do, even though CMS should not have, ignored your court order. Basically, they threw their hands up. We took on the file. We actually didn't take in any fee for it. We just, for me, out of principle only, I had to tell Medicare that they did this wrong. And this is why a lot of carriers and self-insured employers are moving toward non-submits, because CMS unfortunately does things like this. They ignore court orders and they shouldn't. We were able to get the file overturned, the determination overturned, and again, essentially get the MSA right and in the correct place, and keeping CMS in check with abiding by the court order, right? But the TPA didn't have have those connections that we have within CMS to breach the red tape. And ultimately, obviously, we got the right outcome here, saving the client well over $1 million. I believe it was $1.4 million to be exact. So lastly, another example, a defense attorney calls asking for advice after being told by the TPA's internal Medicare division that legal zero MSAs in particular cannot be written or submitted to CMS, right? They just said Medicare is not going to approve them. And that's not true. Well, we do know that as of July 17th of this year, Medicare is going to stop reviewing zeros. This advice was being given by a TPA last year, and it was wholly incorrect. They just didn't want to deal with it. And so really, it's just another example of a TPA not wanting to look outside the box, not trying to be intuitive and consultative with their clients, right? And this is just, again, why, generally, it's better to partner with a specialized MSP provider. Zero MSAs, again, very important update there with Medicare not reviewing those. There's two types of zero MSAs. There's the legal zero, right? There's a no MSA because perhaps the claim is completely denied under state law. And then there's the medical zero, where we have no further treatment required, and the treating physician has certified in writing that no future care is needed. Those are the two scenarios in which a zero MSA is appropriate. And just want to make sure that everyone's aware that Medicare is going to stop reviewing zero MSAs, and Medicare has listed certain circumstances in the reference guides stating what situations support a zero MSA. Of course, if there's no future care, or if the care is denied completely, that would still be appropriate for a zero MSA. You would just now settle without CMS approval. You still want to perhaps obtain a zero MSA for your file and note that in your settlement documents. Just know that even if your settlement is over $25,000 with a Medicare beneficiary, come July of this year, you can no longer receive approval from CMS on that. I'm going to skip through this because I just want to mention briefly a new product that we have here at Sanderson Firm. We now are doing indemnified zero MSAs, or zero IMSA, if the file meets the circumstances that warrant a zero MSA. And we'll of course take a look at it for you and let you know if it meets the requirements, that we feel confident that we can indemnify a zero. Feel free to reach out to your representative here at Sanderson Firm. We'll talk that through with you, but we will fully indemnify that zero MSA. And also I want to talk about one other new product, really exciting this year. It's only April, we've released two new products. One was the zero IMSA, and the second one here is the abbreviated MSA. Essentially, these are for under threshold allocations, right? So settlements with Medicare beneficiaries or reasonably expected Medicare beneficiaries under $25,000, but over $750. We only need 1 year of medical records and the payment history, and we're able to produce that MSA at a much more cost-efficient price. You're now able to demonstrate to Medicare when you're reporting MSAs on all of your settlements above $750 that you've protected Medicare's interests. Just want to let everyone know about our upcoming Sanderson Firm webinar. It's taking place next month on May 21st at 1:30. The topic will be released, I believe, tomorrow. We will be sending out an email webinar about that. And please let us know if you'd like to be automatically enrolled for all of our webinars. Of course, that doesn't mean you have to be live and present for all of these, but it will allow you to receive a copy of the recording in the future in case you can't make the webinar live. Thank you, everyone, for your time and attention today. We hope that this was a thought-provoking, unusual, outside the box kind of webinar. I really enjoyed it. I hope you did as well. Thank you so much, Annie and Brendon, for joining me today. We look forward to seeing you all next month. Wishing you all a great rest of your day. Bye.
Bye, everyone.